And then I'm going to start talking. There we are. Hey, welcome. It's 1 o'clock, time for the Deal Doctor live stream. You have both of your Deal Doctors here today, myself, Don Phelan, and Eric Graham, who is working remotely. So hopefully we can maintain his signal so he can join the conversation here. To open it up, I want to just talk about, go back to the conversations about earnest money deposits. And I'm going to start by asking Eric. Eric, what's rule number one when it comes to earnest money deposits? It goes something like this. If there is a dispute, he's thinking, you can tell he's thinking, okay? If there is a dispute about an earnest money deposit, what does Five Star have to do according to escrow law? Give it some time. I'm going to give you some Final Jeopardy music. Okay, you got about 6 seconds left. 4 seconds, 3 seconds, 2 seconds. Time. What?
If we are holding the escrow money, we are a neutral third party, and Five Star as a brokerage cannot make a determination on who is right and wrong. Therefore, one party will need to sue the other, either through small claims court action or by hiring an attorney.
Yeah. Now, I had a boss once who had a plaque on his wall, and it said, rule number one is the boss is always right. Rule number two is when the boss is wrong, refer to rule number one. So I'm going to go back and say, okay, what's rule number one again?
Listen to the Deal Doctors.
Yeah, when we're wrong, no. We try not to be wrong, or we get help if we are. So
well, when I'm wrong, listen to Don.
The overarching rule about earnest money deposits is that if there is a dispute, we must remain a neutral party. Now, as Eric pointed out, a key point that we're going to come back to is if we are holding the earnest money deposit, we're not always, but we're going to come back to that in a minute. So even though a purchase agreement may say very clearly, unequivocally, that a buyer gets their earnest money back if they don't like the inspections, for example, as just one of many examples, what happens if that seller, with no basis whatsoever, says, I object? What happens?
Yeah, as soon as there is a dispute, again, if we're holding the money, Five Star has to be a neutral third party. As soon as one party disputes the release of the EMD, not be moved, have to go through court action, whether through a small claims or hiring an attorney. And here's the thing. We see this all the time where someone disputes something out of spite, even with merit, and still we can't do anything. We have to sit on the sidelines and say, I'm sorry, now the client's going to have to sue the other party. And we know it's wrong, but unfortunately, escrow laws will not allow us to be the determinant, meaning we cannot determine who is right and who is wrong. We have to sit back and be a neutral party. And the only thing we're going to tell you is this. Your client's going to have to sue the other side, either through small claims or hire an attorney.
So that's kind of the...
But Don, no, what? I mean, I want to know what else I can do. What else can I do, Don? There's another thing you can do.
What's that? Help me.
You can call the Deal Doctors so that we can tell you the same thing I just told you. Your client's going to need to file a small claim action or an attorney, hire an attorney.
Yeah, that's it. I mean, that's the bottom line. I want to talk a little bit about what happens, though, if another entity, for example, a title company is holding the earnest money deposit. What happens then?
Yeah, so every single title company has their own procedures, but they're going to sit back and say, hey, look, until the parties can get it in writing and they can agree, we're not going to release the money. It's going to sit here. And then after a certain amount of time, it may go, they may return it to the state for the state to hold on to it. And then once that happens, after 3 years, boy, no one's going to win that money back because they're going to charge fees. They're going to charge attorney holding fees. Basically, it's don't let it do that. Both parties should come in agreement.
Yeah, I mean, we can send it to the state and send it to essentially the interpleader process. But the interpleader process gets very, very expensive very quickly. And if we're talking about $1 or $2 or $3 or even $5,000 here, going to small claims court to get that earnest deposit, regardless of what side you're on, if you believe you're entitled to it, then going to small claims court is going to be the lesser expensive option between that and going to interpleader, right, Eric?
Correct. Yeah, because the attorneys will say once it goes to interpleader, it's going to burn. You're going to burn up most of that money. Is going to be burned up in attorney legal fees trying to get that. So, what's the point? Yeah, you might as well try to work it out.
Yeah. So one of the things that happens is sometimes agents call us and say, "Well, I told the buyer that they were going to get their earnest money back if the inspections didn't pass muster." Okay, is that what we should be telling our buyers? That if you don't get your mortgage, or you don't have the inspections don't qualify, or you get a bad well and septic inspection, or the title works bad, you're going to get your money back? Is that setting us up for failure?
Yes, it is. And everyone should be told that there's always a risk that the other side may disagree with the release of that earnest money. And as soon as there's a disagreement, that money's going to sit there. No one's going to get anything until both parties can agree in writing. And Don, help us out here when it comes to brokers. So not only do we have buyers and sellers agree, but there are times where with these releases that you might need the sales agents and signature.
Okay, you're breaking up a little bit, Eric, so I don't know if there's something you can do with your signal there. If you're able to, that's great. If not, we'll move on. But the same holds true of the sellers then, right? I mean, that's what you just said, that if we're telling our sellers, well, if that buyer breaches the contract in any way, shape, or form, if they go past the end date, for example, and then choose to terminate the contract, then the seller, you're going to get the earnest deposit. Well, let's slow down a little bit, right, Eric? Maybe, maybe not.
Yeah.
Yeah, because what we then are going to have to do is we're going to have to go back and dig into that contract and identify if there were any contingencies which allowed, that buyer to terminate the contract legitimately. And even so, even if the buyer has no basis on which to terminate, there's still going to be a dispute, which is going to probably need to get resolved at a court level, right? If they're not willing to sign a mutual release.
And Don, I don't know if you can hear me now, but who needs to sign off on that mutual release or that EMD document?
Well, in most cases, it's the buyer and the seller. There are some situations where a broker will require that they sign off on it as well. Now, there's some question about whether or not that's legal or necessary, but the way the form is structured right now, it requires both brokers to sign off on it. Generally speaking, Five Star doesn't engage in that. I mean, it's like, we're going to sign off if our agents ask us to, but I know that some brokers out there will attempt to use that as leverage to get back, advertising costs or whatever they might have invested. So I want to move on. Inspections are the phrase inspections are for buyer's information only. What does that mean? And does that entitle a seller to that earnest money if the buyer terminates based on inspections? Did I lose you?
No, well, no. I mean, informational is for informational purposes, but unfortunately, so many times people will use that language and then use that informational purposes to their benefit, when that was not the true intention, for informational purposes only. So we see a lot of misguided or kind of tricky tricks, I would say, with this type of tactic that is for informational purposes only.
Yeah, I'll give a case in point. We had a situation where one of our listing agents had an offer that said inspections are for buyers' informational purposes only, which would lead one to suggest or to understand that they were not going to use paragraph 15, the paragraph regarding inspections, to terminate the contract. However, when it came down to push comes to shove, and that buyer did in fact terminate based on inspections, then we took it to the attorneys and said, okay, where do we stand here? They said it was for informational purposes only, not to use it as a method to terminate the contract. Well, the attorney came back and said, because that language does not expressly state that the clause in the contract which gives the buyer the right to terminate was not stricken from the contract, it still applied. Isn't that what happened?
Yeah, so it just goes to show you that when we're doing informational purposes only, you need to probably expand on that. That the information or findings will not be cause for grounds for termination, according to section 15 or any other sections that you have in there
So
for well or septic.
Oh, okay, well, great. Did you read my script here or what? Because the next question I have is inspection period extended to such and such a date. Seller to order county well and septic inspection, and buyer will have the opportunity to review the well and septic inspection from the county. So there's an end date on the contract for the inspections. What happens if that report doesn't get in the hands of the buyer before that end date? Who is in breach of contract at that moment? The seller, right?
Seller would be.
Yeah. So how can the seller then say, well, you went past the end date on the contract, therefore I'm entitled to earnest money, even though I didn't get you the information that we agreed that would be provided to you, and that you would have an opportunity to review that before removing the inspection contingency. How can that happen? So this is another example of a case where it's open to interpretation. I'm getting beeped here, I don't know why, but it's open to interpretation when you get into these addenda and these clauses. How are they going to be interpreted by a court in order to determine who's entitled to the EMD? Non-refundable earnest deposits. That's another one. Non-refundable for what reason? Is there anything, is it so broad that it is non-refundable? I see contracts that say earnest money to be non-refundable. Really? Really? Why? You mean if the buyer doesn't get a loan, if the buyer doesn't like the inspections, if the buyer finds out that there's a cloud on the title, which means that they can't close, all of these reasons are reasons that the seller will get the EMD. Let's talk about that. Did I lose your signal again?
No. So non-refundable EMDs, when you see that language, you really need to spell out why. Is it because does the EMD become non-refundable after inspections have been performed, or after the appraisal has been provided? Always need to put deadlines and then consequences, and that's what we end up not most of the times is why is it non-refundable?
So if they had said, for example, earnest money shall be non-refundable once inspections have been approved by the buyer, and if the buyer bails out at some point after that, the seller will be awarded the earnest money deposit. That would be clarification about when that deposit becomes non-refundable and what happens to the earnest deposit if that buyer bails out. Would you agree?
Yes, I would. But keep in mind, they can still say, well, no, I'm not going to do that. And then there's a dispute, but now we got to go to court. But at least you have something in writing that conveyed what the intentions were of both parties. And having that language written will most likely allow the person to prevail in court with a court order,
Okay, so
because it was very clear from the beginning.
right. So back to my statement, rule number 1 and rule number 2, even though there's rule number 2 in place, which very clearly shows that the seller is entitled to that earnest deposit, refer to rule number 1. If there's a dispute, we can't give it automatically to either party, right? It's got
Right.
to go to court and get resolved, because escrow law requires that we remain a neutral party. Are there any questions out there? This is very complex. And I would just caution, as kind of a wrap up, we should never, ever tell our clients, whether buyer or seller, that they are going to be awarded an earnest money deposit as a result of the other party apparently breaching the contract. It's not that clear. And sometimes there's a dispute regardless of how clear it is. Would you agree?
Yes, definitely.
Okay.
There's always going to be risk.
Oh, one more quick thing. When are we required to turn over the earnest money deposit as a buyer? If I collect an earnest money deposit when I write an offer on Saturday afternoon, and we don't get a decision on that until next Wednesday, when am I supposed to turn that earnest money deposit in?
Well, it's going to depend on what's written within the contract, but agents cannot hold on to EMDs. So the occupational code requires it to be surrendered to your broker as soon as possible. But if you weren't able to drop that off on that Saturday evening, it better be Sunday.
Yeah, you can't, as Eric says, you can't hold on to that EMD indefinitely. Either you have to deposit it with the broker, or you have to terminate the thing and, or just say it never went through. It's a dead deal. So,
Or have an addendum. If you know it's signed right away and you're going to have problems getting that money deposited, make an addendum that states that buyer and seller agree that the EMD will be deposited on or before Tuesday.
absolutely. Great. So any questions that you have out there, we'd love to review them and answer you if you want to post them in this thread. And we will see you next week. Thanks for joining. Thanks, Eric, to be joining us on a day you're out with your your young boy.
I'm out in Pine Springs Ministries helping sixth graders with team.
Well, it sounds like a much more fun thing to be doing than real estate all day. So enjoy. Thank you all for joining. See you next week.